Hello everyone, welcome to This Family Does Everything. My name's Alex, and this is a video on the 3 outbursts during the trial. There were 2 verbal outbursts and then one that was a gesture. So let's sit back, watch, and analyze the Darrell Brooks trial.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognized her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is later. Do we know the number? Do you know the number of the jurors, sir? They have numbers.
I just know that I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black shirt.
They're all black chairs, sir. So
the last black chair closest to the television.
Thank you, sir, because there are 2 sides, right? So there's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
Yes. So with that, if we could proceed. This is case number 21CF. A sample of your DNA, sir, has not been taken. I am ordering that now. It may be expunged if you meet the criterion under the Wisconsin statute. Attorney Basie, where are we?
We're fine to proceed. She does not wish to get statement.
Okay. Thank you for checking. Thank you, ma'am. The family is always welcome under the law of the state of Wisconsin, as well as under the amended constitution, have the right to speak at proceedings germane to the particular proceedings that we're at. So with that, I will set bail. I have no problem with the bail being recommended by the state. I'm an old guy who has been doing this for almost 40 years. DA's office, criminal defense attorney, 17, 18 years as a commissioner, both in Milwaukee and now in Waukesha. The nature of this offense is shocking. Actually, the detail I was not expecting here today, that two detectives not lay people, detectives, not only tried to stop this, but rendered an opinion that this was an intentional act. You're presumed innocent, sir, but that's what the allegations are. And I've not seen anything like this in my very long career. It seems to be a very strong case for the state. Likelihood of incarceration, which is the other aspect of bail, is absolute. If you are found guilty of any one of these, a multitude of them, it's a life imprisonment sentence that must be meted out. So I have no problem. I just, with that bail, it's extraordinarily high, but it's an extraordinarily big case. It's an extraordinarily serious case with an extraordinary history of this gentleman, of fleeing, of hurting people, of not following court orders, not following criminal laws, not following just your societal norms. So I know that that's extraordinarily high bail. It's warranted here, and I am setting cash bail in the amount of $5 million. And with that, we're going to select a preliminary hearing date. Attorney Perry, time limits.
Commissioner, we would be waiving time limits. We did, off the record, talk with the clerk prior to this and preliminarily set a date for January 14th at 9:15.
Oh, what day of the week is it?
I believe it's a Friday.
Okay.
Just verify.
Is that a Friday?
It is.
Okay.
Yep, so that date, January 14th at 9:15.
Does that work for the state?
So Judge, it works for my calendar and Attorney Baizey's calendar. We would ask for an opportunity to confer with any victims that wish to attend. Obviously, that cannot be done with haste here this afternoon. So if we could perhaps just notify the court by Monday if we have any significant challenges. I think if the court can anticipate the ability of live streaming the event, that may assist with some scheduling conflicts as well. But I'm available, Attorney Baizey is available, Detective Casey is available. So yes, that is our request for that date.
Okay, why don't we take that date and then we can work out the details as far as live stream or otherwise. We'll talk to Madam Clerk, Monica Paz, and see what we could do. So with that, anything else, Attorney Opper?
No, sir. Thank you.
And Attorney Perry, anything further?
No, nothing else.
All right, very good. We can be adjourned. So I do want to commend the audience. I know this is very highly emotional. I want to commend the defense for doing a fine job, as well as Attorney Opper and Attorney Baizey. So folks, I know this was very difficult. You handled yourself very, very well. I would ask that you continue on in that vein. If you do choose to come to future court dates, you're always welcome back. I do appreciate how you all handled yourself today. So thank you very much.
Thank you, Commissioner.
All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury,
If I may, really quick, pertaining to the last speaker, I have an issue with, if it pleases the court, we can address it later, or if you want to address it now, I'm not sure.
These are sentencing remarks. I'm not going to interrupt those sentencing remarks to have you address him individually.
No, I'm not talking about addressing him individually.
Mr. Brooks, we're going to continue. I'm not sure what you could possibly bring to the court's attention about a speaker who's already made a statement.
A very valid issue that I can bring to the
You
court.
can put it in writing, sir, while you're sitting there, and if it's something I need to address, I will. But I'm not going to disrupt what's happening right now to address that. You need to put it in writing. All right, go ahead, Ms.
So, put it in writing that
Mr. Brooks, please put it in writing.
that's
If you
the
need some
same,
paper,
that's the
then-
same person you had that worked with the father of, right?
Go ahead, Ms. Dunn. Mr. Brooks, please do not interrupt the court.
Like I
The
said, the same
record speaks
person.
for itself. All of those issues were previously put on the record. There's no need for you to make any
That is him
commentary
though,
about
right?
it.
You did work with his father though, right?
Mr. Brooks, stop. If you interrupt me again, you're gonna risk going into the other courtroom. I'm not gonna have
So
you
you gonna hold me in
degrade
contempt?
the integrity of these proceedings.
I'm not
and the
attempting to
solemnity of
cause a
what's going on
controversy. I
right
just
now
wanted to know
by
that.
once again trying to derail what's happening and
And
take
you
the
always
focus
talk
off of
about somebody trying to derail something as if that was the plan, like somebody coming
Mr.
here
Brooks,
to
I'm
derail
advising
something.
you to be quiet or I will clear this courtroom, and under Illinois versus Allen, you will lose your right to be present while the remainder of these individuals give their statements.
Okay, well, come on with it.
Once they start, I expect you to be
Come
quiet.
on with it, because that's what you've been waiting to do the whole time.
Piece of shit. Listen up and listen to what she has to say.
All right.
God damn.
Sir, you're going to have to be removed. I'm sorry. I can't tolerate that from anyone. Mr. Brooks, my admonishment to you is the next person's going to get up and they're going to start their statement. And if
Okay, yeah, but you
interrupt-
made it seem like I'm trying to purposely interrupt that,
Mr. Brooks,
and I don't think
I'm
that's
turning
fair
to
to do
them.
that.
Please be quiet.
Okay, yeah, I still have the First Amendment right to be heard and to speak. I still have that right.
Mr. Brooks, this is a sentencing hearing.
I don't
The
care
trial
what it is. You're not
All
gonna
right.
continue.
He is arguing
You're
with
not-
me. He is now forfeited
You're not
his
gonna
right to be
continue-
present.
you're
Everyone
not
is to
gonna
clear the courtroom
continue.
while he's moved to the next courtroom, and I'll make the appropriate findings when I'm able to do that without
So can I get a
interruption.
finding of fact? Can I get a
I'm
legal
stepping
finding
off
of
the
fact?